All right, it's Wendy Hernandez with Command the Courtroom, and I am live here from my spare bedroom office in Phoenix, Arizona, to do a super quick live stream for you. And we're talking about evidence. This is what we've been talking about this week, and what I'm going to be talking about in my training this Friday, free training Friday. So if you want some free education on gathering evidence that's going to help you in your child custody case, join me during the training. The link is in the description. We're talking evidence. So yesterday we talked about the fact that evidence needs to be relevant in your case in order for a judge to begin to consider it. Just because you bring evidence to the courtroom or you've gathered evidence doesn't mean that it's automatically going to be admitted at trial. Your evidence has to tend to prove or disprove some issue in the case. Whatever you have is that is an issue that evidence needs to tend to prove or disprove that issue before a judge will even consider allowing it. Now, I'm in Arizona and we have pretty liberal rules of evidence. Pretty much we can get anything in, including hearsay, which leads me to the second part, the second hurdle that you're going to need to get over to get evidence admitted. And that is whether or not evidence is reliable. So I had showed you a little worksheet yesterday, if you caught my live stream yesterday, and I'm just going to get that up really quickly. This worksheet that I had created a while ago, it's an evidence screening worksheet. And I recommend people go through their evidence and use this worksheet to determine whether or not the evidence could potentially be admitted at trial. So you list the piece of evidence you want to try to admit, and then you state in the worksheet why the evidence is relevant. It tends to prove or disprove the following material, issue, or fact in your case. And then the next section of this worksheet is the place where you list why the piece of evidence is reliable. So a court is going to need to know why evidence is reliable. And what is meant by reliable evidence is, can the judge rely on it to be authentic? Is it made up? Is there a chance that it is compromised in a certain way? Has it gone through a certain chain of custody? And this is so evidence in law school was an entire semester. So I'm not going to be able to explain it in just a couple of minutes what makes a piece of evidence reliable. But most of the rules of evidence in whatever state you're in, or the federal rules of evidence, try to ensure that before evidence is admitted, that it's reliable, that it's not been altered in some way. So, for example, in Arizona, when I am subpoenaing information, oftentimes what I include in my subpoena request is an affidavit of the custodian of records. And this affidavit is basically a statement by the person who's in charge of the records at wherever I'm subpoenaing them from. It could be a doctor's office, from an employer, and from wherever. And the affidavit of custodian of records is signed by the person in charge of managing the records. And what that person is stating in the affidavit is that the records are true and correct to the best of their belief, or that they represent a true and correct copy of the records that they have in file, that the records are maintained in the regular course of business. We have a little affidavit of custodian of records that we submit to the custodian of records when we're requesting information. And when we get that information back, hopefully the custodian has signed the affidavit and attached it to the records. And that makes it super easy to get the evidence admitted at trial. Because when the custodian has signed the affidavit, the custodian is saying these records are reliable. When I used to do criminal law and there were pieces of evidence that the prosecution was seeking to admit, we would have to show that, for example, if the evidence was drugs, we would have to show that there was a chain of custody of those drugs from the time they left the defendant's body or the defendant's possession and made their way into police custody or the police impound, we had to show who had those drugs every point of the way. When the drugs were tested, the criminologist who would test the drugs would have to sign the drugs out from the locker, say that he or she tested them, then sign them back into the locker. There had to be a custodian of records, a chain of events to show that whatever the evidence was, most often drugs, had not been tampered with, and that the drugs were what they purported to be. So this is really high level stuff. It's not all that easy to understand, but in your case, you should do your best. Whoops, sorry about that. My alarm's going off. You should do your best to ensure that the evidence that you're submitting is reliable, that the court can rely on it. If you're getting information from a doctor's office, see if you can get some sort of statement from the doctor's custodian of records saying this is a true and correct copy of the records on file. See if you can get something from a school saying that. I can tell you that recently I've had cases where the other party provided me and my client with a copy of school records, and those records appeared to have been altered because they did not match the copy of the school records that my client had obtained on their own. So then the question becomes, well, which records are the reliable records? So you have to be able to convince the court or show the court that the records that you're submitting are in fact reliable. The most reliable type of evidence really is when somebody has direct knowledge about some fact, when they have observed something. And a judge is going to make determinations about reliability of a witness's testimony based on that witness's credibility. And credibility is king, and that's a whole other ball of wax, credibility. But the bottom line is your evidence has to be reliable. I've had other parties submit evidence to a judge that clearly looked like it had been altered, like things have been cut and pasted, like things have been whited out. I would argue that evidence would not have been reliable. Another type of commonly used unreliable evidence or evidence that people try to use that's not so reliable is hearsay evidence. There are pretty strict rules about hearsay, and that is because hearsay, generally speaking, is not reliable evidence. So, in order to get evidence in at trial, you first have to show that it's relevant, which we talked about in yesterday's video. The second thing you have to show is that the evidence is reliable. And if you'd like a video series where I go more in depth into what constitutes reliable evidence, that's something I might consider doing. Leave me a comment and let me know. I am just doing these short little live streams every day to connect, but there's not enough time really to go into depth. But if you'd like more depth about what type of evidence is reliable, that's something I might consider doing. So tomorrow, though, we're going to talk about the third R of evidence, the third hurdle, which is just the first hurdle of getting evidence admitted to trial. And that is whether the evidence is, quote, right to be admitted. So you have to ask yourself, is your evidence reliable, relevant, reliable, and right? But for you, the thing to focus on at the moment is number one, those best interest factors, which are my favorite thing to talk about. Those are the factors that a judge looks at in determining what is going to be in the best interest of a child in a custody case. So you look at those best interest factors. If you have not already downloaded the best interest checklist, do that now. And once you know what best interest factors apply in your case, then you go about collecting the evidence that relates to each of those factors that apply. And that is the most important thing that you should do. So many people lately are coming to me and saying, well, I don't know where to start gathering evidence or what evidence is really the best evidence. So I'm going to talk about that in this week's training, the free training on Friday. If you haven't already signed up for the free training, the link is in the description. Go to the registration link, sign up. You have another day or so to take part in it, and hopefully I'll see you there. The topic that we're talking about today, getting evidence admitted at trial, is not the easiest topic to understand. So don't beat yourself up if you feel like it is a lot, because it is. But you're taking the first step by watching this live stream and trying to understand. That's the most important thing, is taking action in your case and not letting things just happen to you in your case, getting educated, doing the work, investing the time, rewatching the videos, re-reviewing your notes. You have to do that. Even if you have an attorney, you should have an understanding of what the law says, what's going to be required of you, because when you have that expectation, you're going to do a better job in your case and at your trial. You're going to build a stronger case if you understand. You cannot rely always on attorneys, even your own. Sometimes attorneys drop the ball. Sometimes attorneys are newer attorneys and they don't know the law as well as they should. And sometimes you can see things that an attorney can't see. Sometimes an attorney has blind spots. Sometimes you have a more creative mind as somebody who is not educated or schooled to think a certain way. Sometimes you have unique or novel ideas that your attorney doesn't have. And I love when clients bring their ideas to me. Excuse me, I'm tired today. I have a headache, but I wanted to come on because I said I would. But the point is even if you have a great attorney, you still have something to add by getting knowledge about your case and being informed about the law and making suggestions and providing evidence and providing information that your attorney may not know to ask for. You know your case best, so it's up to you to be your best advocate. So I hope this little live stream helped. I see that there's been some people on here. I love when I hear from you, when I get comments. If you haven't already signed up for that best interest checklist, go to commandthecourtroom.com, sign up for the checklist now. If you have not got registered for the free training on Friday, do it now. Please do it now. And if you can't make it to the free training on Friday, I'll be giving a replay of that training for probably just a couple of days so you can watch it later and take notes and take screenshots. But you have to register. And the other thing I want to mention is when you register for free training Friday, you're going to get access to my newest fillable PDF. It's called the Best Interest Building Blocks. I'm going to share it super quickly. And it's this neat little PDF that I created. I had fun creating. I love making things for you. So this is the Best Interest Building Blocks PDF. You're welcome, Beach Nut. This is the Best Interest Building Blocks PDF, and you can fill it right in on your computer screen. So I list the different areas, the different best interest factors, and I even leave some blanks for you to fill in your own that apply. And then you can just type right in there what you think applies. You can type in their potential evidence. You can type in just general notes. You can type in names of witnesses. It's a super cool little kind of mind map summary tool that's going to help you. So when you come to the training on Friday, come ready with your Best Interest Building Blocks PDF, either printed out or on your screen, ready to take notes. We're going to go through some fact patterns, which I love doing. And we're going to talk about hypothetical situations. And when you learn how I would handle a hypothetical situation or a real situation, that, a client that comes into my office, and you're going to start learning how you can do the same thing in your own case and have the same system and the same process. And that's what it boils down to. Like, you don't have to go to law school to do a decent job in your case. You just have to have a process. You just have to have a system. So you're going to learn mine. It's not the only system, not the only process, but it's better than nothing. Okay. I think that's about it. It's about 5:05 p.m. here in Phoenix. Thanks for watching. If you're watching it now or if you watch it later, I'm going to head out because I'm super tired and I have a headache. And anyways, hi, Fernando. So I hope to see you on Friday's training. Re-watch this replay if you didn't catch the whole thing. Sign up for the free training, get the Best Interest Building Blocks, and take action in your case. Most importantly, get out there and command the courtroom, and I'll see you soon with another video. Okay. And you are very welcome. I'll see you soon. Bye.